Now, a defense attorney is this evening taking issue with sections of the new Firearms Act, saying the procedures to ensure fair and just outcomes for those accused. Now, in addition, the attorney argues that the proposed law does not consider what takes place on the ground in inner cities. Andrea Chisholm picks up that story.
Prominent defense attorney Peter Champagny is making his position clear. Crime is high, and there should be harsher penalties for gun crimes. Under the newly proposed Firearms Act, persons could get a minimum of 15 years in prison if found with an illegal weapon. Mr. Champagny, however, believes certain procedures should be followed to prove someone is innocent or guilty.
Whenever the police assert that they have taken a firearm, for example, from the waistband of an accused person, that DNA testing should be done in respect of that firearm. And quite frankly, there can be no excuse for not doing this.
That's because the 2016 DNA Evidence Act is in effect. The police, he suggests, can partner with Indicom to get the job done. The attorney also argues that the proposed law does not take into account exceptional circumstances, cultural issues, and the reality of those living in inner cities. Case in point, Albert Paulton versus the Queen. In 2013, Mr. Paulton, a middle-aged man, was at home when the police were pursuing a man believed to have a gun.
The man found refuge in Mr. Paulton's premises and threw a firearm at him and told him to lock it up, police are coming. And the police, within seconds, went into the said room. And as the police entered, the appellant, Mr. Paulton, said, "Officer, this man just gave me a firearm to put up, seat over there in a pan." And all of what was said by Mr. Paulton was confirmed. There was really no issue with the case against him. In the end, he was found guilty because the judge at the time did not accept that there was sufficient duress in terms of what he was positing as his defense, among other things.
Due to his record and character, Mr. Paulton was given 12 months probation for illegal possession of firearm and 2 months probation for ammunition.
Now I ask you, would it be just and right for that man, if that situation were to happen today with the existence of this new legislation, would it be just and right for 15 years, minimum mandatory 15 years, to be meted out to him? I think not. So I would want to see a situation where there are exceptional circumstances.
Then there's Clause 18. A person should not profess to have a gun to gain an unlawful benefit. For Mr. Champagny, the aim is to get the guns and gunmen, not pretenders. Though he agrees the offense should be on the books, the penalty needs adjusting.
Given the situation by virtue of the provision, 15 years in the circuit court, we could well do without that and let the parish court have treatment of it in terms of a maximum sentence of 5 years.
Meanwhile, Mr. Champagny argues that the provision to review the act after 7 years may suggest the legislation is draconian.
We have to be mindful of what we are doing, and this indecent haste sometimes often lead to serious mistakes.
The 2022 Firearms Prohibition, Restriction and Regulation Act is now before a joint select committee of Parliament. Andrea Chisholm, TVJ News.